they propose a sort of framework for figuring it out, which is you look at the circumstances of the event and you say, is it more like a State of the Union address or is it more like a campaign event? And they look at the January 6th speech and say, this is outside the outer perimeter. And so this has enormous implications for a lot of personal litigation against Donald Trump during the period that he's president. A lot of people have withheld such litigation on the theory that Nixon v. Fitzgerald was a very broad grant of immunity, which it is. But here the D.C. Circuit has articulated a limit of that immunity. And I think one that is likely to carry some weight with the Supreme Court.
I'm Natalie Orpett, Executive Editor of Lawfare, and this is the Lawfare Podcast, December 5th, 2023. On Friday, two courts weighed in on the question of presidential immunity. First, Judge Chutkan of the D.C. District Court ruled that Trump is not immune from Special Counsel Jack Smith's criminal prosecution for his conduct on January 6th. In the second, the D.C. Circuit Court ruled that Trump is not immune from a civil suit brought by members of Congress and Capitol Police officers, also relating to his conduct on January 6th. To talk through the decisions, I sat down with Lawfare senior editors Quinta, Jurecic, and Roger Parloff, along with Lawfare Editor-in-Chief Benjamin Wittes. We discussed the nuances of both opinions, how the analysis is consistent and how it is different, what each case implies about the other, and what comes next. It's the Lawfare Podcast, December 5th, 2023. Two courts rule on presidential immunity. Okay, so we have two very interesting opinions that came out of the D.C. Circuit and the D.C. District Court this week, both relating to the question of whether Donald Trump has immunity. But both of these cases are actually presenting the question quite differently. So we will go through each one in turn. Quinta, I want to start with you on Judge Chutkan's ruling out of the District Court in D.C. This is, of course, in Jack Smith's, Special Counsel Jack Smith's criminal case against Donald Trump in connection with January 6th. So can you tell us what this case was about and what Judge Chutkan ruled?
Trump has filed a variety of motions to dismiss in the case against him in Washington, D.C. over his involvement in January 6th. And this opinion from Judge Chutkan focused on Trump's motion to dismiss the charges against him on the grounds that he is immune from criminal prosecution as a former president, as well as on some separate constitutional grounds having to do with the First Amendment and the Due Process Clause. So I'll focus here on the immunity argument. In Trump's motion to dismiss on the grounds of immunity, what he's essentially trying to do is take existing doctrine that establishes that the president is immune from some civil suits for actions that are within the outer perimeter of his presidential responsibilities and extend that to the criminal space, arguing that he is absolutely immune from any kind of prosecution regarding January 6th because he was the president while those actions took place. There are some additional complications there, but that's the broad strokes of it. And I think it is fair to say that Chutkan was not particularly impressed by this argument. She's definitely a fan of the well-placed zinger. And she writes at the beginning of this ruling, whatever immunities a sitting president may enjoy, the United States has only one chief executive at a time, and that position does not confer a lifelong get-out-of-jail-free pass. So no total absolute immunity for former presidents in the criminal context. Her reasoning in very, very broad strokes essentially is that the reasoning that the Supreme Court used to apply civil immunity to sitting presidents just simply doesn't apply in the criminal context. You're just not worried about chilling presidential actions in the same way. And again, here we have a zinger. She writes, every president will face difficult decisions. Whether to intentionally commit a federal crime should not be one of them. She also points out that whereas in the civil case, you might be worried that a president, after he leaves office, could be bombarded by civil lawsuits for all kinds of official actions he took. That's just not present in the criminal context in the same way, especially because we're focusing here only on potential federal prosecutions. And she writes also, that there are all kinds of procedural safeguards in the criminal justice system, including, for example, the ability to move to dismiss a case for selective prosecution, which Trump is also attempting to do. She writes that there is a strong public interest in a criminal prosecution, in that, and I quote here, "A former president's exposure to federal criminal liability is essential to fulfilling our constitutional promise of equal justice under the law." And so she really kind of comes out here with a ringing statement about the meaning of the rule of law, the meaning for what it means for everyone to be equal under the law, and takes that and says Trump's argument about absolute immunity from criminal prosecution for former presidents is simply off the table. She does make clear that she is not delving into some of the more complicated questions about whether this applies to state prosecutions, whether how we sort of navigate the dynamic of a sitting president versus a former president in this context, whether the line drawn in Fitzgerald about the outer perimeter of the president's official responsibilities applies here as well. She's really just saying there is not a sort of sweeping absolute immunity for former presidents from criminal prosecution.
So was it your sense, based on the factors that you just listed, that Judge Chutkan was trying to write a narrow ruling that was specific to the admittedly quite unique facts that are presented to her here?
No, actually. And I think that this is a way that her ruling really differs from the DC Circuit ruling in Blessing, which we'll talk about in a minute. That she is really saying, look, Trump has made this very, very broad, sweeping, high altitude argument about absolute immunity from criminal prosecution. And I'm going to address this at a similarly high altitude. She explicitly says, essentially, I'm not going to dig into the question of whether the conduct for which Trump has been indicted is within the outer perimeter. I'm not going to look at whether inquiring into the president's motive for undertaking that actions, whether that kind of inquiry is constitutionally permissible. I'm just looking at this very, very high level question. So she's sort of moving in very broad strokes here, as opposed to the DC Circuit, which is really trying to say, we're going to take a look at how to understand, the specifics of whether this does or doesn't fall outside the line drawn in Fitzgerald. We're going to look at the specifics of the particular actions here and sort of provide a framework for the district court in analyzing that conduct.
Okay, so we are going to come back to immunity, but I did want to spend a couple minutes on the other aspect of this ruling that you mentioned, Quinta, which was she also denied the motion that Trump made on constitutional grounds, which related to the impeachment clause. So, Roger, can you tell us what Trump's original argument was in this vein and what Judge Chutkan ruled about it?
Yeah, there are, among the constitutional arguments he made was an argument that the impeachment judgment clause prevents him from being prosecuted. And this is important, like the immunity clause. It's one of the immunity ruling can almost certainly, it can be the subject of an interlocutory appeal, which could stay the whole case. And that's obviously terribly important. Similarly, double jeopardy is subject often to interlocutory appeal if you lose a motion to dismiss on double jeopardy grounds. Although if it's frivolous, then it doesn't have to be stayed. Here, one of the claims had to do with this, the impeachment judgment clause, which says, judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy so-and-so the office. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. So what Trump had argued was that, well, that says the party convicted shall nevertheless be liable and subject to indictment. It doesn't say the party acquitted. He was acquitted at impeachment, and he constructs an argument that you have to first go through impeachment and then be convicted before a president can be indicted and tried in a conventional criminal setting. And she rejected that argument on multiple grounds. To begin with, there are two Department of Justice Office of Legal Counsel rulings on this sort of argument. And those aren't binding, of course, but they have weight, and they're from different one was having to do, it was 1973, it was Vice President Agnew, and one was 2000. I assume it was Bill Clinton, it doesn't say. But one was during a Democratic administration, one was during a Republican administration. They both reached the same result that, no, that's not what this clause means. She analyzes it and says, the first part of the clause is about restricting Congress's the punishments from the impeachment itself. It's only about removal from office and possible disqualification from holding office. That's different from things from apparently in England, where the legislature itself could impose criminal type penalties. And so that first clause is restricting it. And then the second clause is explaining that nevertheless, meaning even though the legislature can't pursue you, you can be pursued in a conventional criminal setting once you're no longer in office. So that's the gist of what's going on. And she also uses she also points out that this is the logical fallacy of, quote, denying the antecedent. And she gives the example from the statement, if the animal is a cat, it can be a pet. It does not follow that if the animal is not a cat, it cannot be a pet. Yet defendant argues that because a president who is impeached and convicted may be subject to criminal prosecution, quote, a president who is not convicted may not be subject to criminal prosecution. And so she rejects that argument, I think, in pretty strong terms. So we'll have to see if that if she regards that as a frivolous argument that would not warrant staying the case, or whether that's just a normal, it's a ruling on a case of first impression, which is technically the case, and it might be something that an interlocutory appeal would stay the whole case.
Yeah, I'm glad you brought up the cat being a pet example. I thought that was a nice example of the types of zingers that Quinta was talking about before. I will just note that the 2000 OLC opinion that you mentioned is actually by Randy Moss, who's now a federal district judge, which of course came out during the Clinton era. Ben, do you have any thoughts on the significance of that being included?
I mean, it's one of the two times that the OLC has addressed the amenability of the president to criminal prosecution. And as Roger notes, both times the OLC concluded that a sitting president was not, but at no time did it suggest that a impeachment and conviction was a prerequisite for indictment after service in office. And so, look, Judge Chutkan here is responding to a flamboyantly extravagant claim of immunity on the part of the former president. And it's one with very little, it has essentially no textual support, very little historical support. And the plausibility of it rests entirely on the fact that the Supreme Court created the presidential immunity doctrine in Fitzgerald in the civil context. And it seems a little weird to say, well, the president is immune from civil liability, but you can prosecute him criminally for the same conduct. And that's really the entirety of the argument, is that, well, they immunized the president against civil liability, so it follows that he, of course, must be immunized against criminal liability. That was never going to work at the district court level. There was never a chance, I don't think, that Judge Chutkan would rule any way other than the way she did. And the question that the opinion raises, of course, is are there 5 votes at the Supreme Court or, a majority of DC Circuit judges who are willing to entertain this argument, which would basically involve spinning this doctrine, I wouldn't say out of whole cloth, but out of some cloth. It's a stretch. And the major significance of these 2 cases coming out as they did the same day is that it actually gives you a bit of a window into how the DC Circuit is going to think about this, which I assume we'll get to shortly. The bottom line is it doesn't look good at the DC Circuit level for the former president. And so if this immunity argument is going to prevail, it's going to have to prevail at the Supreme Court.
Yes, we will definitely come back to that. I just want to spend a brief moment. Roger, I know you've given some thought to the fact that this is, although a very unique situation with respect to Trump, the legal question is not totally unheard of. So can you talk to us a little bit about what we know from previous case law and just history in general about this question of criminal prosecution and impeachment?
Yeah, there were these, as I said, the 2 OLC memos, and then historically, and this might be mentioned in the OLC memos, but there are people that were prosecuted without being first impeached and convicted in the impeachment setting, like Vice President Aaron Burr quite early on. And then at least 4 judges, I can't think of them all now, Walter Nixon, Alcee Hastings, and 2 others. So, there is historical precedent. And I should say generally just that, this Chutkan's opinion did have lots of, like you say, zingers and bon mots, but it was really well reasoned and I think pretty bulletproof. And one other thing she noted is that, like in Nixon versus Fitzgerald, which is the case you're going to be hearing a lot about with respect to the civil case, that was the case that set the rules about there is some considerable immunity in the civil case context. All 9 judges, there were 3 opinions, but all 9 judges agreed that this did not, they were not writing about the criminal context. And 4 of them were very strong about it. Justice White wrote, he stressed that no party had argued, quote, that the president is immune from criminal prosecution in the courts, nor would such a claim be credible. So that's very strong. And the other voices on the court at that time were, they were distinguishing it forcefully. So anyway, I just think it's a very solid ruling legally as well as in a powerful literary sense.
Okay, Roger, that was in Nixon v. Fitzgerald, is that right?
Yes.
Okay, Ben, you've given a lot of thought to that opinion. What do you think?
So, Roger is correct that all of the justices in Nixon v. Fitzgerald said this is not applying to, criminal matters. But in the dissent, which was written by Byron White, he kind of calls the majority out on the fact that distinction is actually incoherent. And he writes at one point in the dissent, the court intimates that its decision is grounded in the Constitution. If that is the case, Congress cannot provide a remedy against presidential misconduct, and the criminal laws of the United States are wholly inapplicable to the president. I find this approach completely unacceptable. I do not agree that if the office of the president is to operate effectively, the holder of that office must be permitted without fear of liability and regardless of the function he is performing, deliberately to inflict injury on others by conduct that he knows violates the law. So, I think the best argument for immunity, and it's not an argument that is going to work at the district court level, it's really an argument that only works at the appellate court level, is that if you're grounding this in separation of powers, which, is kind of the theory behind Nixon v. Fitzgerald, that it's a fundamental, the immunity is a fundamental incident of the office of the presidency itself, that it doesn't really make sense to apply it to the civil context and not to the criminal context. And that the effort to do so is kind of arbitrary.
Yeah, and I think this is an interesting point that's just bears emphasis, which we've intimated at, but just to make it explicit, this is really the first time that the question of a president and immunity in the criminal context has come up. So when Trump wrote this motion, it relied very, very heavily on the premise that the civil context was analogous and really the only important consideration in making this determination about criminal immunity.
And to be clear, nobody disagrees with Roger that, in fact, it is different, right? Everybody has proceeded from the Nixon case, not Nixon v. Fitzgerald, but the Nixon criminal case, right? He wouldn't have needed a pardon if he had been immune. And Ford granted him the pardon. He accepted the pardon, right? And so he never said, I don't need this because I'm immune. Bill Clinton reached basically a non-pros kind of plea agreement with the office that had been run by Ken Starr. No reason to do that if you're immune. So nobody has actually acted like they believe that there is criminal immunity. And that said, no president has been indicted because of the pardon of Nixon and the plea agreement involving Clinton. No president has been indicted, and so you've never had occasion to test it, particularly in the years since Nixon v. Fitzgerald. But this argument is one, I don't think it has, I'm quite confident it doesn't have 5 votes on the Supreme Court, but it probably has 1 or 2.
Yeah, and I think in this sense, the fact that it hasn't been presented in this way to a court makes it all the more interesting that Judge Chutkan chose to write a higher altitude opinion here. So on this question of the civil context for immunity, let us move now to the D.C. Circuit's opinion issued on the very same Friday afternoon in the case Blassingame, which used to be called Thompson v. Trump, which I think people are more familiar with under that heading. That was brought by Congressman Benny Thompson and a host of others, including other members of Congress, as well as some Capitol Police, I believe, and some other individuals trying to sue Trump civilly for incitement for having caused their injuries on January 6th. That opinion came out, 3-judge panel. Ben, can you tell us about the case and what the circuit ruled?
Yeah, so first of all, the Chutkan opinion was expected, and it's an important opinion in the trial of Donald Trump, but it is exactly, I think, what everybody expected her to do, and thus is really no surprise. The D.C. Circuit opinion is an extremely big deal, and it's for a few reasons. The first, it took the D.C. Circuit a year to write this opinion. It's an appellate court opinion, which means it is precedential and, binds the D.C. Circuit, other panels of the D.C. Circuit, and it binds the lower courts, including, importantly, Judge Chutkan. And then the third reason it's a big deal is that it is quite cross-ideological. It's written by the chief judge of the court, Sri Srinivasan, who's an appointee of Barack Obama. On it, however, all of it is Judge Gregory Katsas, who is a sort of very conservative judge who previously, before being on the D.C. Circuit, served in the Trump White House counsel's office, as well as in the Justice Department. He's a sort of luminary of the conservative bar. And then the third member of the opinion, who joins all of the substantive argument, but kind of picks nits on some of the procedural aspects, is Judge Judith Rogers, who is an appointee of Bill Clinton. So this represents, a very wide swath of the political and ideological spectrum of the DC Circuit, and particularly because this panel is composed of very well-respected judges from both the conservative and the liberal side, it's going to carry a lot of weight at the Supreme Court, I suspect. All right, so what is the opinion about? The case involves civil suits against Trump for having allegedly inspired or provoked the riot on January 6th. And it's brought by, it's actually several cases brought by Capitol Police officers and by members of Congress. The president had argued, the former president had argued that he was immune from this lawsuit under Nixon v. Fitzgerald, that he was just giving a speech. Giving a speech is one of the functions of the presidency, and therefore he is immune from suit as a result. The district court had rejected this on a theory that's actually different from what the DC Circuit adopted, and the Justice Department had urged really focusing on the non-protected nature of incitement as a means of resolving it. And the DC Circuit sweeps all this aside and proposes a different test of how to evaluate whether a presidential speech is within the outer perimeter of the president's authority. And what they say is, look at the speech, not the contents of the speech. What he says doesn't matter. But look at the circumstances of the speech and ask, is this an official function? Like, is it the State of the Union address, or is it a bill signing, or is it an official presidential visit to, Qatar? If it is, he is absolutely immune for what he says, even if what he says is a crime. That's the meaning of presidential immunity. Conversely, if it is not an official function, and in this case, the speech was organized allegedly by private actors, he's there as a seeker of the office of president, not as the holder of the office of president. So a campaign event that's paid for by the campaign that he's not using government personnel for, these are outside the outer perimeter of the president's office, and he's just like any other citizen for that. Now, they acknowledge that these two things can be, in the case of the person of the president, can be sometimes a little tricky to figure out which one we're dealing with. And so they propose a sort of framework for figuring it out, which is you look at the circumstances of the event and you say, is it more like a State of the Union address or is it more like a campaign event? And they look at the January 6th speech and say, this is outside the outer perimeter. And so this has enormous implications for a lot of personal litigation against Donald Trump during the period that he's president. A lot of people have withheld such litigation on the theory that Nixon v. Fitzgerald was a very broad grant of immunity, which it is. But here the DC Circuit has articulated a limit of that immunity. And I think one that is likely to carry some weight with the Supreme Court. So I think this is just an enormously consequential opinion.
So I want to ask, just on the legal question, one of the things that a lot of commentators were saying about the difficulty of the question presented was this notion that because the claim related to incitement, that asking whether a president could be immune from incitement, in this case, would require the court, if you made the calculation about what the president intended, which is, of course, an important consideration for incitement, that it would require sort of burrowing your way into a president's head. So to what extent, Roger, I'm interested for your thoughts on this. To what extent do you think the court was attracted to this idea of looking at circumstance in the way that Ben describes, rather than having to consider intent?
Yeah, that was true. And even, I think more broadly, they wanted when you make an immunity decision, you want to make it as early as possible, because the idea is that he's being harassed in some inappropriate way or his functions are being diminished. And here, the question of did he incite violence was a very contested issue. And so, ordinarily the rule is, well, we take the complaint's allegations as true for the purpose of a motion to dismiss. But it's going to be very easy for plaintiffs to allege that people broke the law in various ways, or committed wrongdoing. And they did not want to have a situation where they granted immunity and then on a basis that turns out to be false. Of course, in the end, we are going to revisit this question at the summary judgment phase, so they didn't avoid that altogether. But they tried to find something extremely objective that wouldn't, like you say, that wouldn't involve looking into intent and motive, and that can be determined on its face. I think the language is, as an initial matter, the government had suggested that you could deny immunity to him because the allegation was that he was going to incite imminent private violence. And they were saying, as an initial matter, the government's suggested approach could lead to our denying immunity to President Trump based on an assumption that turns out to be false, indeed an assumption that President Trump has already contested. So this was a way of getting around that problem.
Quinta, what are your thoughts on this distinction between circumstances and intent?
Yeah, so 2 points here. One is, I think it's worth noting how this focus on what the court describes as an objective context-specific assessment rather than an inquiry into motive, I think kind of allows the court to frame the framework that it's set out as very generous to presidents and former presidents. So Srinivasan writes that, when this inquiry, and I quote, yields no sufficiently clear answer in either direction, the president, in our view, should be afforded immunity. And then he goes on to say, conversely, when a president's actions viewed objectively and in context may reasonably be understood only, that's my emphasis, as re-election campaign activity, a court not only may, but must deny immunity. And I note that Judge Katsas in his concurrence also really drills down on this language of an objective inquiry, context, et cetera, et cetera. And so I certainly read that as saying, look, everybody, we're not trying to ask, what lies within the former president's heart. Not only are we looking at these sort of outer trappings, but we're doing so in such a way that really allows the president or former president a fair amount of leeway in terms of whether or not we decide to grant immunity. The other point that I found interesting is that, to connect this back to the US v. Trump prosecution, one of the arguments that Trump is having with the special counsel in the briefing on that is whether or not this inquiry into motive is permissible. And Trump says that it is not in the context of a criminal prosecution when you're trying to determine immunity. And the special counsel says, well, yes, it is ruled out under Fitzgerald, but this is simply a different situation because this is a criminal context. And that aspect doesn't apply here. And so Chutkan kind of doesn't touch on that specific dispute because, as we've discussed, she's really ruling at a very high altitude. But I think it's worth noting insofar as we're trying to kind of map out the overlap and cross-cutting between these different opinions.
Yeah, I think that's an important point. And I do want to come to soon comparing these opinions and thinking about what they say about each other. Roger, I know you had some additional thoughts on this opinion and this question of the distinction between political capacity versus presidential capacity.
Yeah, I think there's another way in which Srinivasan is trying to make the ruling as narrow as possible, because he keeps mentioning over and over the fact that Trump, in a sense, himself admitted that he was acting in a personal capacity, not an official capacity, with respect to much of his attempts to reverse the election results, because he entered a motion to intervene in the Texas versus Pennsylvania case in December 2020. You remember that's the weird original jurisdiction case that in which Texas was trying to persuade the Supreme Court to throw out the results in 4 swing states. And when he did that, when he tried to intervene, he said he was doing so in his, quote, personal capacity as candidate for re-election to the office of the president, personal capacity. He also wrote that he grounded his right to intervene in, quote, his unique and substantial personal interests as a candidate for re-election to the office of president. Obviously, it's going to be very rare that a plaintiff is going to be in a position where suing the president, where the president has already agreed, said somewhere that he was acting in his personal capacity and not official capacity when he committed the acts that are the subject of the suit.
Yeah, I have to say it does seem to me that the attempt to draw a very clean line between political capacity and official capacity, or personal, as you say, and political is a bit tricky when it focuses on speech. You know, are you talking about if the speech given is in the context of a previously scheduled political event that was sold as such? You know, what do you do about speeches that are on the road for other things, but seem to the world to be political in nature? I think it is not so clean in practice. You know, and the Texas v. Pennsylvania, as you say, case raised some interesting additional data points here for thinking about this issue. Quinta, you gave a lot of thought to that case. What are your thoughts on this?
I have been interested in this question of, you know, why was it that Trump chose to intervene in this, really underlining this personal capacity in this suit? I will confess I've had some difficulty tracking that down. So if any Lawfare listeners recall, please give us a shout. But I will say that looking at the January 6th report, the committee's report, there's an interesting data point here about December 29, 2020 meeting that Trump had with members of the Justice Department and Mark Meadows, where Trump essentially wanted to file an additional complaint challenging the results of the 2020 election, essentially, according to the committee, modeled after Texas versus Pennsylvania. Trump wanted the Justice Department to do this, and the Justice Department officials essentially refused. So that doesn't speak directly to the fact that Trump was intervening in a personal capacity in Texas v. Pennsylvania, but I do think it's kind of an interesting data point that when we're looking at, you know, why was it that Trump chose to frame this as really the personal action of a candidate, that he then later that same month tried to essentially get the government to weigh in an official capacity, sort of wearing his president hat, and wasn't able to. I think that might perhaps strengthen even more the line that the DC Circuit is drawing here.
Yeah, I think it's an interesting point. And, you know, as we're talking, it's very clear that there are a lot of complicated but quite nuanced issues here. And it strikes me that it's important that although all 3 judges on the panel joined the opinion, 2 of the 3 chose to also write concurrences. And, you know, typically that's done when everyone can agree on the outcome and the main framework of the analysis, but the concurring judge has some additional stuff to say. So, Ben, what did you make of the 2 concurrences and how they compared to the main opinion?
So the Katsas concurrence, Judge Katsas joins the majority opinion, Chief Judge Srinivasan's opinion, in its entirety. So his opinion is very much for the purpose of kind of adding a little bit of explanatory material. No part of it takes issue with anything in the majority opinion. It just emphasizes a few points that for one reason or another are important to Judge Katsas. In particular, he seems to have a concern to emphasize that this is not holding that Trump doesn't get immunity. It is holding merely that if the facts are as proved to be as pled in the complaint, which they have to take as true at this point, then Trump is not entitled to immunity. Judge Rogers' concurrence is a little bit more complicated. She joins the substantive components of the opinion, but she has a bunch of kind of prickly words for the framework that the analytical framework that the other two propose to the lower court for how to think about how to handle these immunity questions. And she seems to think that none of that is properly before the court, and that she kind of accuses them of sort of micromanaging the way the district court is going to handle this, which actually seemed to me to be a little bit ungenerous, frankly. But the body of her opinion, she definitely joins substantively the body of the majority's opinion. So I would say that there is a minor difference among the DC Circuit judges in how much guidance they should give to the lower court about how to handle this going forward, but there's no substantive difference among them that I can discern about how to analyze these facts as an immunity question. And that actually is striking, that you get a panel of the DC Circuit and it's substantively unanimous on this.
Yeah, absolutely. And it occurs to me, I think Roger mentioned this earlier, but Judge Katsas in particular is leaving some room for, if in fact the government is not able to prove its case to his satisfaction, I mean, not his personally, to one's satisfaction, that there is plenty of room to reconsider this issue in the context of a summary judgment motion. Let us turn now to looking at these cases together, which obviously they are not part and parcel of the same proceeding, but from a practical perspective, they relate to the same types of facts and they are happening at the same time. So they are not in direct conversation with each other, but they do in fact really influence each other and are likely to have an impact going forward, particularly because I think we all can expect that Trump will bring an appeal of Judge Chutkan's ruling on the motion to dismiss. So Quinta, you had emphasized to me in a previous conversation that it was interesting to you that both cases are presented at this, with a lot of emphasis on how this is a preliminary stage. What else do you think is important about that?
So the way that I read that was that, these cases both have really important implications, obviously, for what's going to happen in both these pieces of litigation. But I mean, honestly, really, I'm focused on the criminal prosecution of Trump. And I know Ben has thought about the interaction here. So Ben, I'll be interested to know what you think, but that there's a little bit of kind of emphasizing, to the public, don't get out over your skis here, so to speak. Srinivasan really emphasizes repeatedly, and I think this is part of what seems to make Judge Rogers perhaps a little irate. We're ruling here on Trump's motion to dismiss. That means that we have to take all of the allegations as pleaded. So perhaps Trump could, for example, on a motion to summary judgment, demonstrate that he was in fact acting in an official capacity and so on and so forth. Judge Chutkan also, as I mentioned, is really explaining here, I'm only looking at the question of whether Trump possesses absolute federal criminal immunity for any acts committed while in office. So they're kind of playing down what they're doing here, even as I think it's very significant. And Srinivasan also, it's worth noting, says explicitly at the beginning of the ruling, we're really only looking here at civil litigation. We are not looking here at the question of a criminal prosecution. That said, there are some obvious implications about what this might say in terms of how the DC Circuit could potentially consider Judge Chutkan's ruling. And on this, I'll turn it over to Ben.
Yeah, Ben, what are your thoughts on this? Is this an instance of Justice White's dissent being particularly apt?
So, look, I think there is a sense in which the two issues are not that closely related, right? Judge Chutkan is addressing whether there is immunity at all in the criminal context, and she says no. The DC Circuit is addressing a different question, which is where there is immunity, and they're not addressing the question of is there immunity in the criminal context. How do you separate the question of what are you immune from what aren't you immune from, i.e. the personal from the presidential? There's another sense, however, in which the two issues are very closely related, and I think the DC Circuit has in important respects showed its hand. So, first of all, it would be really strange for the DC Circuit to hold that, like, a speech on the mall that provokes a riot, you are not immune from as a civil matter from liability. But, the larger pattern of conduct that it's part of, you're completely immune from as a criminal matter. That would be a very weird sequence of DC Circuit rulings. More broadly, I think it is fair to say that this opinion shows that the DC Circuit's tolerance for the idea of broad immunity in the presidential arena it's a bit narrower than people expected. I'm very surprised that there wasn't a dissent from this. And I think if you say that the DC Circuit as a body is a less friendly forum to sweeping presidential immunity claims than we may have expected it to be, or then it doesn't seem likely that same DC Circuit is going to turn around and say, oh, but we're going to extend Fitzgerald, having just said Fitzgerald's a little bit narrower than y'all probably thought. We're going to now sweepingly extend it to be an absolute immunity from criminal stuff, which, as Roger pointed out, 9 justices of the Supreme Court had said, we're not going there, or this Fitzgerald doesn't go there. So I think it is, as a matter of tea leaf reading, it's very hard for me to imagine that the same DC Circuit that issued this opinion is going to reverse Chutkan on the extension of Fitzgerald to the criminal space. Perhaps the more urgent question, because ultimately that question is going to be decided by the Supreme Court, not by the DC Circuit. Perhaps the more urgent question involves whether the March 5th trial deadline is going to actually happen, the trial date. So Judge Chutkan has set a trial date for March. Her ruling, for reasons we can go into if you want, her ruling rejecting presidential immunity is subject to interlocutory appeal. And the question of whether the proceedings get stayed while that interlocutory appeal happens has a lot to do with whether the trial deadline the trial date will really happen in March. And I think this does suggest to me, at least again, reading tea leaves, that the DC Circuit is unlikely to stay a trial based on a theory of immunity that involves greatly widening the theory, the current presidential immunity, having just said, by the way, the immunity, Fitzgerald immunity, isn't quite as broad as you think. And then finally, I will just point out, and I have not studied the indictment with this question in mind, so take this as very tentative, but the opinion does mean that if Chutkan is wrong, and eventually there is Fitzgerald immunity, under this DC Circuit framework, you would have to go through this indictment and do a context-specific analysis of each act in the indictment and say, hey, is this a private act or a public act? And some of those acts, like, threatening to fire the acting attorney general, clearly public acts. But a lot of the acts, like calling Brad Raffensperger, not clear to me that those are acts in his capacity as president versus his acts in his capacity as an office seeker. And so I think, this opinion could mean that even if somehow Tanya Chutkan got reversed on the immunity question, a lot of the indictment would survive.
Okay, I want to come to both Roger and Quinta for your thoughts on this question, because it does seem to me that this is, as Ben says, there is some tea leaf reading here, but it's an interesting question. So, Roger, to come to you first, what are your thoughts on what these cases have to do with each other, the interaction for thinking about what these issues mean and what they're likely to mean going forward?
Well, I agree with Ben, and for the reasons he stated, that there's just a very strong a fortiori type argument. I mean, if he's not even entitled to what we used to call nearly absolute immunity from civil suit on these facts, it's almost inconceivable that he's, entitled to some immunity from criminal prosecution. Nixon versus Fitzgerald was a 5-4 ruling about whether the president should even get immunity in the civil context. There's never been, well, I won't say never, but we do have some other officials, judges and prosecutors that get so-called absolute immunity from civil suit. They are not protected from criminal prosecution. So there's just no, it's a much, everyone sort of assumes it's a much steeper hurdle. And I read the language from Justice White, and it's true, about that he just thought it wasn't convincing, it wasn't plausible practically that they weren't even ruling on that question. So that's the main takeaway I got. There's a side point going back to the Texas versus Pennsylvania thing, where he admits that he has a unique and substantial personal interest as a candidate for re-election. It happens that could conceivably become an important admission because one of the charges against Trump is this corrupt obstruction of an official proceeding. And one of the argued meanings of corruptly is doing something to get a personal benefit, doing something illegal for a personal benefit. And here he is saying that he had a huge, unique, and substantial personal interest in becoming a candidate. But that's sort of a sidelight and a contingent issue. But the overwhelming one is the one that Ben described.
It seems to me it's sort of an interesting dynamic. There's a bit of a catch-22 in comparing the crime of corrupt obstruction of a criminal proceeding and this test, perhaps, of personal versus political. What can a political candidate act corruptly, or is that effectively a personal situation? How much of it is circumstance? How do you decide that? It seems like a very difficult inquiry. Okay, Quinta, and let's wrap it up with you. What are your thoughts on the interaction of these two cases?
I think what we've really seen over the course of the Trump presidency, and this is an argument that I've made in Lawfare, is Trump sort of attempting to collapse the distinction between himself as a person who occupies or occupied the office of the presidency and the presidency as an institution, and trying to kind of merge those together. And we see this in his argument about absolute criminal immunity, that everything he does is official and that he should retain that immunity even after leaving office. I think what we see here in these two rulings in different ways are courts saying, no. And they take different approaches to that. They go through that inquiry at different levels of altitude. But I find it kind of interesting as a symbolic rebuttal, if you will, to this argument that Trump has been making and that I think is not only is now, but has always been at the core of his vision for what the presidency means and his place in it.
Okay, I think we are going to leave it there. Quinta, Roger, Ben, thank you for joining us.
Thank you.
The Lawfare podcast is produced in cooperation with the Brookings Institution. You can get ad-free versions of this and other Lawfare podcasts by becoming a Lawfare material supporter at our website, lawfaremedia.org/support. You'll also get access to special events and other content available only to our supporters. If you're interested in our analysis of the many trials of Donald Trump, join us for our weekly live event on Thursdays at 4 p.m. Eastern. Please rate and review us wherever you get your podcasts. Look out for our other podcasts, including Rational Security, Chatter, and The Aftermath, our latest Lawfare Presents podcast series on the government's response to January 6th. Check out our written work at lawfaremedia.org. The podcast is edited by Jen Patja Howell, and your audio engineer this episode was Ian Enright of Goat Rodeo. Our music is performed by Sophia Yan. As always, thank you for listening.